For transparency advocates, the framework governing personal data in India threatens to become a permanent barrier. The vital flow of information between the state and its citizens now risks being locked away entirely. The legality of this framework will be tested on May 13th at the Supreme Court. A coalition of civil rights groups, journalists, and transparency advocates have filed consolidated writ petitions with a singular objective: to scrap the Digital Personal Data Protection Act, or DPDPA, of 2023. They argue the legislation and its subsequent 2025 rules are entirely void. Through a writ of mandamus, they demand the courts strike the law down from the books. The legal machinery mobilized for this challenge is massive. The petitioners are represented by leading advocates, starting with Indira Jaising and Abhishek Manu Singhvi. They are joined by veteran legal strategists like Prashant Bhushan and Vrinda Grover, leading a highly coordinated attack across 4 separate petitions. This maps the mechanics of their argument. On the left are the precise clauses of the DPDPA. On the right are the constitutional rights they allegedly violate, specifically the rights to equality, free speech, and personal liberty, outlined in Articles 14, 19, and 21. To understand the upcoming hearings, we must map the petitioners' grievances against the government's primary defense: that the Act is a highly specific administrative tool that is simply being misread. The outcome will decide whether the Indian state has engineered a statutory loophole to bypass the constitutional privacy protections of its own citizens. The first major friction point lies at the intersection of data protection and the public's right to know. Petitions from Venkatesh Nayak and the Reporters Guild explicitly target Section 44(3) of the Act. This clause amends the Right to Information Act, severely restricting the type of personal data the government is obligated to disclose to the public. Cutting off access to state records actively suppresses the freedom of speech guaranteed under Article 19. A secondary attack isolates Section 7 of the DPDPA, pointing out a glaring omission. It offers 0 proportionate exemptions for processing data for journalistic purposes. Without that exemption, investigative reporters can be legally penalized for handling the personal data required to expose corruption, leaving their confidential sources entirely exposed to corporate and state scrutiny. The map shows this omission driving directly into the constitutional protections for press freedom and the right to practice one's profession. Because these sections inform the rest of the framework, the petitioners are simultaneously asking the court to quash Rules 5, 6, 17, and 18, along with multiple schedules. A data law structured to shield government operations from the press cannot coexist with the democratic mandates of Article 19. Defending the framework against these charges is the central government, represented by Solicitor General Tushar Mehta. His defense hits its steepest challenge on the issue of state surveillance. Section 17(2)(a) grants the central government unilateral power to exempt its agencies from the framework. Petitioners argue this fractured legal reality violates Article 14's Equal Protection Guarantee, as state agencies operate with total immunity, while private companies face heavy penalties. That inequality is compounded by the architecture of the law's designated watchdog, the Data Protection Board. Under Sections 19 and 24, the appointment, tenure, and service conditions of the board are entirely dictated by the executive branch.
Geeta Seshu's petition demands the court mandate a constitutionally compliant mechanism to separate the board from executive control. An oversight body whose members serve at the pleasure of the government cannot impartially judge a data breach committed by that same government. This structural failure ties directly back to Article 14 and threatens the personal liberties enshrined in Article 21. The state grants itself blanket immunity while holding the leash of its own regulator, creating an asymmetry of power that the petitioners argue is wholly unconstitutional. But the grievance that impacts the average citizen most directly is the removal of financial restitution. In this flowchart, we see the effect of Section 44(2)(a). This clause explicitly extinguishes the right of an affected person to seek civil compensation if their data is unlawfully processed. The petitioners view this as a denial of justice. It leaves individuals financially defenseless against massive corporate fiduciaries who leak their data. But here is where the legal interpretation drastically diverges. An intervention petition filed by the Foundation of Data Protection Professionals in India offers a completely different reading. According to legal analysis from data protection experts at Navi, the petitioner's outrage stems from a total misreading of how the Act is meant to function. They argue Indian law operates concurrently. The new legislation doesn't erase old laws, it stacks on top of them. This cross-section visualizes their defense. The DPDPA 2023 was never designed to be a monolithic enforcer of privacy rights. It is strictly an administrative layer. Its only job is to levy fines against data fiduciaries. It doesn't handle personal damages because it wasn't built to. Look at the architecture beneath it. The Information Technology Act of 2000 and the constitutional right to privacy remain fully intact. To seek financial relief, a citizen bypasses the new law and uses civil remedies available under the ITA 2000. The interveners point out that separating state-issued administrative fines from citizen-driven civil damages is exactly how the GDPR functions in the European Union. From their perspective, there is no constitutional crisis. The government simply needs to issue clarifications to explain how these laws work together. This leaves the court with two irreconcilable interpretations. Is the Act a dangerous vacuum of civil rights, or a highly specialized module sitting on top of a robust legal foundation? Looking at the complete structural map, the sheer density of the upcoming legal battle comes into focus. The petitioners see a state apparatus using sections 7, 17, 19, and 44 to insulate itself, weaponizing citizen data while stripping journalists of their defenses. The Solicitor General and the interveners see a targeted regulatory tool that perfectly complements existing IT laws, fully compliant with the Constitution. Untangling these two realities falls to three specific judges. The bench, headed by the Honorable Chief Justice, alongside Justice Joy Mallya Bagchi and Justice Vipul M. Pancholi, will hear the consolidated arguments. Their choice is binary. They will either scrap the DPDPA entirely, forcing Parliament back to the drawing board, or they will validate the concurrent framework theory and let the law stand. The ruling will immediately dictate the operational reality for every data protection professional, tech company, and legal scholar in India. When the gavel falls in May 2026, the Supreme Court will permanently encode the boundary line between a citizen's absolute right to privacy and the state's insatiable appetite for data.